Anyone who's heard in New York and consults with a lawyer wants to know, how long is my case going to take? When am I going to be compensated? I've heard that question hundreds of times in my career. And if I was a client, I'd be asking the same question. It's a fair question. The answer, if a lawyer's being honest, might not be the most satisfying one, but this is the truth. It depends. It depends on the facts and circumstances of your case. What I can promise any consumer, any client hiring our firm, Block, O'Toole & Murphy, is this. The case will take as long as it needs to take, and only as long as it needs to take, to get you all of the compensation that you deserve. If settling early means settling cheap and not getting you what you deserve, we're not interested in that. We're not going to do that. We're not going to let the defendant or the insurance company off the hook. We're going to push and push to get you the right result. Sometimes that takes a short amount of time. Sometimes that takes a long amount of time. But what matters is getting you what you deserve. Lots of factors can contribute to delays in cases, and many of them are outside of the control of the client and the lawyer. For example, the court system. The court system in New York is crowded. There's a lot of litigants getting into that courtroom door. There's a lot of cases every judge has to deal with. And sometimes it's a matter of waiting in line for a trial date so that we can go and pick a jury and take a verdict. And that doesn't necessarily happen overnight. Another factor that can cause delays in a case is that new parties sometimes are added to cases after they're started. We may, on your behalf, sue a defendant. That defendant, after a few months or even after a year, may realize that they can actually bring in another party who's responsible for the accident or who's responsible for indemnifying them as a defendant. So the addition of new parties over time can cause case delays. A client does have some control over certain delays. The best way that you can control the speed with which your case proceeds is, number one, hire a lawyer right away. Don't wait. I have met clients who waited 2 years after their accident to first consult with a lawyer. And I'm always very grateful that they found me and that we can help them. But also, I realize, and they realize, the frustration that they sort of wasted 2 years of litigation time. Hire a lawyer right away. Explore your rights right away. And if you have a valid case to bring it, and don't wait. Another way that you can control delays in your case is by showing up when you're supposed to show up. If you have an appointment to give a deposition, be there. Show up for the prep session, show up for the deposition. Otherwise, it might get adjourned. It might get adjourned for months. If you have an examination by a doctor on behalf of the defense, which they're entitled to in most injury cases, be there. Be prompt. If you show up when you're supposed to show up, you can save months, if not years, of potential delay on your case. Usually the longest part of a lawsuit is the discovery phase. Now, the discovery phase of a lawsuit means the time in the case when the parties, the plaintiff and the defendants, exchange information with each other. That means we're making demands of the defendant for certain documents or videos or photographs. We're receiving them, we're reviewing them. Maybe we're realizing we weren't given everything we were entitled to. We demand more. The same is true in the opposite direction. We're providing records, perhaps they're medical records or photographs or incident reports, to the other side. That's called documentary discovery. Discovery also includes depositions. That's where both sides ask for witnesses from the other, swear them in, and ask them questions. Some cases there are only 2 depositions. Some cases there may be 20. Of course, it just depends on the case. That process of discovery, of gathering information, documents, witnesses, subpoenas, sometimes involves going to the court and arguing over what we're entitled to or not entitled to. That often takes a very significant amount of time. At Block, O'Toole & Murphy, our job is to get through that discovery process, getting all the information and facts we need to prove your case, but also getting to the point where we finish discovery as efficiently as we can so we can move on to the next step, which is getting onto the trial calendar and either settling your case or bringing it to verdict. Settlement negotiations can really happen at any point in a case. Our philosophy at Block, O'Toole & Murphy is we're always thinking on 2 different tracks. One track is litigation and pressure. We always want to be applying pressure to the other side. We want to present your case in a way where the defendant and their insurance company understand that our firm is confident, comfortable, pushing the case toward trial to get you justice. We want them to feel that risk of an impending verdict, because at the same time, we're always thinking about track number 2, which is there a way to get a fair settlement, a fair resolution for our client that brings them an amount of monetary compensation that's right and also brings them finality, an end to the case, an end to the stress of the case. If you're running toward trial with blinders on, never thinking about settlement, you're not taking care of the client. If you're just thinking about how to get out of the case and settle the case and you're afraid of trial, you're also not taking the client. You have to be aware of both. And if you are, you may find an opportunity to settle a case very, very early. It's possible, and it happens quite frequently. It may be that you have to litigate the case for years, right up to the doorstep of trial, to settle that case. It really depends. But you always have to have an open mind to all possibilities and be ready to talk if the other side is willing to talk in a way that's fair. A client has every right to expect proper, regular communication from his or her lawyer. Does that mean once a week? Does that mean once a month? Does that mean every single day? Well, the answer is it depends on the client. At Block O'Toole Murphy, we sincerely believe that our boss is the client. The client is in charge. It's your case. It's your case, and it's your right to know what's going on when you want to know what's going on. Our firm's philosophy is there's no right or wrong answer to how much communication there should be. As a client, you have a right to talk to your lawyer when you want to. There's no single answer to how long a personal injury case takes in New York. Even giving an average amount of time is somewhat misleading. It really depends case to case. I've handled cases that have settled within a month of me being retained as a lawyer. I've also had many cases that have taken many, many years to reach their resolution. In every instance, the real question is this: how long does it take to get you the right result? How long does it take you to get full and fair compensation? It could be a matter of weeks or months. It could be a matter of years. The only way to really know that answer is to hire the right attorney, trust that attorney, walk through the process with knowledge, with communication with the lawyer, and understand that when you get to the finish line, which hopefully is as quickly as possible, you're happy with the result.